Welcome, members, guests. Today is Wednesday, March 9th, 2022. I hereby call the Subcommittee on Elections and Campaign Finance to order. Madam Secretary, please take the roll.
Representative Holtzclaw. Representative Love.
Here.
Representative Manis. Representative Shaw.
Here.
Representative Williams. Representative Wright.
Here.
Chairman Crawford. Chairman Rudd.
Here.
Chairman Rudd, you have a quorum.
Thank you. Let's see, are there any personal orders or announcements from members? Seeing none. Today we have 14 bills on the calendar. A few have been rolled. We'll get to those as we come. First up is item number 1, HB 2675 by Leader Lamberth. You have the podium.
Thank you, Mr. Chairman. And the bill is very straightforward. On days that a member receives per diem, if they have additional expenses, they could utilize campaign accounts to defray those expenses if they obviously go above and beyond the per diem amount.
Are there any questions on the bill? Seeing none, ready to vote on the bill. All those in favor say aye. Aye. Opposed, nay. Bill goes on to full local.
Thank you, Mr. Chairman and members of the committee.
And next up is item number 2, HB 2280 by Powell. Is Chairman Powell here? Oh, you are. I was looking in the audience for you.
I'm easy to disappear.
Let's see. Do you you don't have any amendments or anything on your bill, do you?
No, I do not.
All right. Please tell us about your bill.
Sure.
Oh, do I have a motion and a second? A motion and a second. Please tell us about your bill.
Sure. So this House bill would allow candidates running for state or local office to use their campaign funds to pay for campaign-related child care or dependent care expenses. The Federal Election Commission ruled in 2018 in a bipartisan ruling that candidates running for Congress or federal office could use their campaign funds for child care expenses. 26 states have passed similar legislation. As you know, sometimes the ability to have child care or dependent care could be a hindrance to those that wish to run for office, and this would simply allow, in the code, make this an allowable expense. With that, I'm open for questions.
Have any questions? Any questions on the bill? Seeing none, you ready to vote on the bill? We are hereby voting on HB 2280 by Powell. All those in favor say aye. Aye. Opposed, nay? No. I hear one no. And I'm a no.
We got 2 yeses over here. Want to do a roll call?
Yeah, we'll do a roll call.
I have the votes.
Representative Holtzclaw. No. Representative Love.
Yes.
Representative Manis.
Yes.
Representative Shaw.
Yes.
Representative Williams.
No.
Representative Wright.
No.
Chairman Crawford. Chairman Rudd.
No.
3 ayes, 4 nays.
Bill fails.
Thank you, Mr. Chairman. Member.
Next up is item number 3, HB 2074 by Griffey. Do not see him. We will roll that to the hill. HB 2305 by Griffey. He is not present. We'll roll that to the hill. Number 5, item number 2011 by Representative Cassada. Let's see, I believe you have an amendment.
I do. Good afternoon, Chairman and Committee. It's
Or motion and a second. I have a motion and a second. What is your code on your amendment?
014970.
That's what I have. Here, a motion second on the amendment. I have a motion and a second on the amendment. We had it on the bill. Second. I have a motion and second on the amendment. I believe, tell us about your amendment.
This amendment makes the bill that creates a process so that a citizen of the state can file a complaint against a county election commissioner. The simple process is the complaint is filed. The chair of the state election commission has 10 days notice of the meeting. The evidence is presented by both sides, and the state election commission determines if action is needed.
And I think the amendment just removes the state election commission, only applies to the county election commission.
That's correct.
Okay.
That's correct.
Any questions on the bill? Mr. Representative Shaw.
Thank you, Mr. Chairman, and to sponsor the bill. My election commission, I talked to both of them. I got two. They just think it really put them in a bad way because during an election, there's so many attitudes and different opinions about things, and sometimes people just get mad when there's no cause to get mad, and they just feel like they being put on a hot seat for something that maybe they shouldn't do. I guess what I want to ask you, have we had anything like this to happen in Tennessee where people needed to be sued for some reason?
Well, this would not address being sued. It just simply addresses being removed from the board. And we've had some occasions where the legislator had to step in. And I don't need to give specifics because it might shine light on people.
Yeah.
But there were times, as you know, this committee knows, we appoint those
Right.
county. And there has been a couple of occasions where the legislator that appointed them said, look, this is unbecoming behavior. You need to step down. And they complied. But I am of the opinion this is not our role as legislators. And so there must be a show cause. There must be a reason. It's not arbitrary. The Election Commission has a code of conduct that would be used to determine if they should be removed or not by the State Election Commission.
Representative Shaw.
What is that code of conduct? Can you explain that?
They adopted it themselves. I don't have that in front of me, but it's their own code of conduct that they've adopted.
Well, I thank you for bringing the legislation, but because I don't do this every day, I normally call my election commission office when these kind of pieces of legislation come up to see how they feel about it, and my folks feel a little uncomfortable, so I'll be voting no. Thank you.
Mr. Chair, if I could just say, this is an uncomfortable bill because those people that I've appointed, they are my friends. But I just don't think it's our responsibility to be supervising that. And number two, and most importantly, it just opens up a process for the citizens to have their input and not just us. So that's the purpose of the bill.
Chairman Williams.
Thank you, Chairman. Representative Cassidy, I appreciate the intent of this bill. I actually had a problem in my election commission in my district, but there's already a policy and procedure in place where they petition through the election administrator to the administration, the director of elections, Mark Owens. I had an issue there. My concern about your bill is that it would create a second pathway, which lead to further confusion. I recognize you may have a problem there, and we do appoint these people, but the current system in Putnam County works. It's unfortunate that we occasionally have to go through this situation, but I recognize what you're trying to do, and I think it's good, but I won't be supporting your bill. Thank you.
We are on the amendment now. Let's go ahead and vote in the amendment on the bill. We are voting on Amendment 14970. All those in favor say aye. Aye. Opposed? No. Amendment is on the bill. Is there any further questions on the bill as amended? Seeing none, we're voting on the bill. 2011. All those in favor say aye. Aye. Opposed? Nay. Nay. Sorry, bill fails.
Thank you, committee and Chairman. I appreciate the time to present this. I did feel the cold wind coming in, and that's going to blow me on out of here.
We are now on item number 6, 1914 by Eldridge. And it is rolled 1 week. He's to the hill. Next is item number 7 by Representative Dixie, HB 0561. And he is here. There are motion and second on the bill. Motion. Second. We have a motion second on the bill. Are there any amendments to your bill?
Sorry, I think I had an untimely.
We have an untimely, just a moment. We have an untimely filed amendment. I understand that. Any objections to voting to take up the untimely filed amendment? Seeing none, we're voting to take up, what is the amendment code? Is it 12884?
Yes.
All those in favor of voting to take up the untimely filed amendment, say aye. Aye. Opposed, nay. We can take up the amendment. Now we're on the amendment. You want to tell us about your amendment?
Yes, thank you, Mr. Chairman. Thank you, committee. So the amendment does make the bill, and I want to talk to you a little bit about this bill. This bill will require the county election officers and the election division to suspend the voting rights of people who are convicted of felonies for the duration of their sentences until they are eligible to re-register to vote. Currently, a person with a past felony conviction who meets certain criteria is eligible to restore his or her rights to vote. A person convicted of a felony can have their rights restored if they are granted clemency or after having completed their sentence and paid all court costs, fines, restitution, and be current on child support payments. But those individuals who have been convicted of murder, rape, treason, felony bribery, misconduct involving public officials, interference with government operations, sexual offenses, or violent sexual offenses that are felonies where the victim was a minor or voter fraud are permanently barred from voting. However, a person may not register to vote until they have obtained from a supervising or incarcerating authority a certificate of restoration, verifying that they meet those criteria. Once the certificate is contained, we'll call it the COR, the Certificate of Restoration, the COR, is submitted to the Elections Division, which again verifies the individual meets this criteria. So why this bill is needed? Tennessee is one of only 3 states that require people who are statutorily eligible to restore their rights to vote to obtain additional paperwork to register to vote. The certificates of restoration serve no functional purpose except as a barrier to disenfranchised people. Under the law, a person cannot receive a COR unless they have met certain eligibility criteria. The election division already verifies that anyone who submits a COR meets those criteria. So in essence, CORs make for redundant bureaucracy and it wastes taxpayers' money. This bill removes the redundant paperwork requirement by allowing people who meet the criteria to register to vote and their registrations to be approved upon the election division, verifying that they meet the statutory criteria. This bill allows voting rights restoration for individuals who have completed their sentences and are back in their communities. Under the current law, if an individual is determined to be eligible, there's a multi-step process that must be completed to regain their votes. Just quickly, these are the quick flow chart of what someone has to go to get their rights restored. Then this is just if it's in one county. So if you move from one county to another, you have to complete this process all over again. So between 2016 and 2020, roughly about 3,400 individuals were able to get their rights restored. So that's less than 1% of individuals who have completed their sentence. I think we can do better than this. The added requirement of paying fines, fees, and restitution and child support have resulted in unequal voting access based on wealth. Over the past few decades, there's been a trend towards restoring the voting rights for those who have been disenfranchised, and the momentum continues to grow. 35 states and Washington, D.C. have expanded voting rights to citizens with felony convictions on their record. 2 states have no voting restrictions, which means that incarcerated individuals can absentee vote while in prison. 21 states allow automatic restoration when released from prison. 14 states allow restoration after completion of their sentences and probation. Only 11 states have permanent prohibitions on voting rights. Tennessee is one of them. In addition, Tennessee is the only one of 3 states that require certificates of restoration. Governors in Virginia, Iowa, Kentucky issued executive orders restoring voting rights to individuals upon completion of their sentence. Iowa's governor, Kim Reynolds, stated at the sign of her executive order, quite simply, when someone serves their time in their sentence and pays the price our justice system has set for their crimes, they should have their right restored to vote, automatically, plain and simple. When When individuals return to communities, they must feel as they are part and able to participate fully in society that includes voting. The American Probation and Parole Association, APA is what it's known as, members firmly believe that voting rights to those released from prison encourages rehabilitation and assists community supervision officials and law enforcement efforts to promote public safety. This organization is an international professional association with members throughout United States, Canada, and other countries who work in probation, parole, and community-based corrections. These professionals supervise more than 5 million adults across the nation and know firsthand the challenges faced by those reentering society after incarceration. This organization strongly believes that bringing people with past convictions into the political process is an important part of rehabilitation and successful reintegration into society. Continuing to bar people from the polls brands them as an outsider and prevents full participation in their communities and hinders reentry efforts. Participation in the voting process affirms an individual's value to the political process and strengthens public safety. It encourages participation in civic life and deepens community connections. If we all believe in truth in sentencing, then we should believe when someone pays the full judicial price, their dignity and voice should be restored. This bill protects the interests of public safety and the inalienable rights we all share. With that, Mr. Chairman, I'll answer any questions, but I think there were some people here that would like to testify.
We need to take a couple of technical issues up first. We have we voted to hear the amendment, but I need a motion and a second on the amendment that we just heard. Your motion second on the amendment. We need to attach the amendment. If there's no further questions on the amendment, we'll attach the amendment to the bill. All those in favor say aye. Aye. Opposed, nay. Bill is amendment's attached to the bill. Let's see. Do you want to call up the testimony? We have guests. We'll go out of session here. We have one organization with four speakers. If you'll come up, we have 3 seats, and if necessary, we'll make way. We're out of session to hear speakers. And please introduce yourself. There's a button on the. Just make sure the red light's on the button, on the main button. I believe it's on the left. If it's lit, you're active.
Should I go now or?
What order you want to go in? And then when one of you's finished, if the fourth person wants to speak, you can trade places, or they can speak from the podium. All right, go ahead.
All right. Good afternoon. Thank you for the opportunity to address you today. My name is Amy Little. I've lived in Sullivan County, Tennessee for 34 years. I'm a wife, a mother of 3. I'm a certified peer recovery specialist. I serve on the Recovery Resources Board of Directors, and I'm part of the Tennessee Department of Mental Health and Substance Abuse Services Planning and Policy Council for Region 1. Working with the Sullivan County Anti-Drug Coalition, I helped launch a pilot program providing case management and peer recovery services to folks who are incarcerated in the Sullivan County Jail. I'm also a volunteer grant writer, and so most recently I wrote a successful grant for the Sullivan County Sheriff's pretrial release program. And I'm also permanently ineligible to vote in the state of Tennessee for an offense I committed as a teenager. I've never voted, and unless the law changes or I move away from my home state, I never will. And so, to me, it sends the message that no matter how I've grown or how I work to better my community, I'm forever unworthy to be represented or to have a voice in my own governance. I'm sorry. That rejection is something that you carry with you. It's a feeling of otherness, and at one time the stigma that I encountered, trying to find work, and that feeling, it fueled depression and substance use, and the policy of disenfranchisement alienates the people that we should be trying to reintegrate, making it counterproductive to public safety. Connection is how we mitigate crime. That's how people and communities recover, by bringing folks back into the light. When we're connected, we're accountable. We want to be redeemed in the eyes of others. Civic participation helps us feel invested in our communities and gets our buy-in on this social contract that we're expected to abide by. Punishment alone doesn't restore or offer a path to redemption, and redemption should be a possibility for all. And that's why Tennessee needs a restoration process that's streamlined and fair, and I think this bill achieves that. So I hope that as you consider it, you'll keep me in mind and others like me in your own districts. Thank you.
Thank you. My name is Blair Bowie. I'm Senior Legal Counsel at Campaign Legal Center. Thank you, Chair Rudd and the committee for having me today. Over 450,000 Tennesseans are unable to vote under the current law. More than 80%, 365,000 of those people have finished their entire sentences, including probation and parole, meaning that in 40 other states, they would already be able to vote. But in Tennessee, less than 1% of that post-sentence population has been able to get their voting rights restored. One major reason for this is that Tennessee is one of only 6 states that conditions the right to vote on the payment of legal debts. This bill would put an end to that. And let me be clear, this bill does not impact a person's legal obligation to pay restitution, court costs, or even child support. It simply decouples those debts from the right to vote. And the reason for that is because under the current law, a rich person and a poor person could be convicted of exactly the same crime, given exactly the same sentence, but the poor person would be disenfranchised indefinitely while the rich person could simply buy their right to vote back. That's not how democracy is supposed to work. Whether or not we can vote should not be determined by the size of our bank accounts. There's no evidence that withholding a person's right to vote leads to more people paying back restitution or other legal debts. On the other hand, studies do clearly show that restoration of the right to vote improves reentry results. A person who successfully reenters is more likely to have the economic ability to pay back their legal debts, improving outcomes both for victims and people with past convictions. The other reason why 99% of Tennesseans who have finished their sentences still cannot vote is the redundant bureaucratic requirement that a person obtain a certificate of restoration. The certificate is unnecessary. 47 states and the District of Columbia have figured out how to verify their citizens' eligibility after a felony without a certificate. Why can't Tennessee? Only 2 other states have a certificate requirement like this, Wyoming and Alabama, and both actually have far superior systems to Tennessee. Here, it can be extremely difficult to find an officer willing to complete the certificate, and the certificates that do get filled out aren't always accurate. In fact, 8% of certificates submitted are ultimately rejected because the applicant is not actually eligible. Ms. Pamela Moses, standing at the podium right now, was recently sentenced to 6 years and 1 day in state prison because a probation officer negligently made an error on her certificate. It's already the job of elections officials to independently verify that every person on the voter rolls is eligible to be there, and I think we can agree that that's how it should be, and that's true under both state and federal law. The certificate does nothing except waste taxpayer money and stand as a barrier to the ballot box. So I encourage you to pass HB 0561 to decouple legal debts from the right to vote and eliminate unnecessary certificates of restoration. Thank you.
Greetings from Shelby County. My name is P. Moses. I'm a graduate of the University of Tennessee at Knoxville. During my graduation, former Governor Bill Haslam spoke of the success of his brother, who owned the pilot gas stations that you now know as Flying J. 3 months after I graduated from UT, I was sent to prison for domestic crimes I committed while suffering from postpartum depression. These were my first convictions, but as a felony, Judge Leibowitz saw me as a troubled person with an ineffective lawyer. She sent me straight to prison. I was never given judicial diversion or able to have the matter expunged. That was in 2000. Consequently, the felony stayed on my record forever because this is the law in Tennessee. I managed to stay out of trouble and avoid homelessness because my parents provided me with a home, but I was never able to have gainful employment or seek nice housing because of the references blemished on my criminal record. I moved back to Memphis to create music and realized that the music business was as political as the lawmaking here in Nashville. I struggled so much that I became a social justice activist for life. My political beliefs have caused me to be persecuted because I pointed out everything wrong in Memphis. That was a big mistake. I became a target due to my criticism of corrupt public officials. Despite my innocence, I was held on a $500,000 bond and falsely imprisoned for comments on Facebook. I was accused of stalking a judge. My unexpunged crimes as a teenager like her allowed the DA to paint me as a dangerous person. I can't tell you every detail of my life, but I can tell you my brother is not the governor, and my family doesn't have any billionaires. When I reflected on Governor Haslam's speech during my inauguration, he said, we, the class of 2000 at UT, could be anything we wanted to be. But I now know he wasn't talking about me or people like me. 12 years, the Flying J president received 12 years in prison. And I'm only mentioning this to you, body that doesn't look anything like me, that I want to show a parallel between socioeconomics and race is something that we must look at. The state of Tennessee treats disadvantaged people very differently, and the process is very complicated for an educated person like myself. No one in this state should be prosecuted for a flawed process. In this committee, Chairman Rudd, I ask under your direction that you allow the automatic restoration to occur, and I'm asking you to pass this bill without any objection or any discussion because I know you want to go home by April. Thank you for your time.
Good evening. My name is Keita Haynes, and I just want to thank you for having this opportunity to speak before you. I am the Voting Rights Campaign Strategist at the Sentencing Project. And the Sentencing Project is a national research and advocacy organization that's based in Washington, D.C. For years, the Sentencing Project has worked on voting rights issues and generated national reports with state-level estimates on individuals that are impacted by felony disenfranchisement. Not only am I the Voting Rights Campaign Strategist at the Sentencing Project, but I am also a former public defender from here in Nashville, and for years I have engaged in various aspects of criminal justice reform, including mass incarceration, collateral consequences, and voting rights restoration. Like so many others in this state, I too have been disenfranchised because of a felony conviction that's on my record. Sharing these lived experiences with those is one of the reasons why I fight and do the work that I do today. So as a representative of the Sentencing Project, I sit here before you and acknowledge that we support this legislation and also ask that this committee support it and pass it. Thank you.
Do we, while we're out of session, do we have any members that want to question any of those giving testimony? Seeing no hands, I want to thank you, you ladies, for testifying. We'll get back on the bill, but thank you very much. We'll go back into session. We're now back on the amended bill. Do I have any questions? Chairman Williams.
Thank you. Does the leader believe that restitution is a component of the overall conviction of criminal offense, or does the sponsor think that they're not related?
I think it is can you hear me?
Yes, sir.
It is a component of that. Restitution is definitely a component. But I think that we should look at that and take it in context. And I think it's also a civil matter, too. Sometimes when we look at the restitution and they try to pay it back, the system is so convoluted, they don't know who should receive the restitution. Sometimes it's a business. It's very rarely a person, but sometimes it just gets convoluted and it gets lost in there. And then somewhat, because they don't know where to appropriate the funds, it gets lost in the system and they can never jump over that hurdle.
Chairman Williams.
Thank you. That's my concern about this. The courts adjudicate based upon convictions, and the court orders restitution as a part of that. And there's no question that these ladies that testified here today have paid their their responsibilities as it relates to their jail time, but we can look at the data and look at the restoration of their voting rights, but the vast majority of those who haven't had them restored have not fulfilled the entirety of their sentence, which includes restitution. As much as I understand that, the former governor and the ability to pay, that is part of that conviction. And so to ignore that, for the body to ignore that, is to water down the law. And so I'm a little bit concerned about that, but I don't want to be the only one to ask a question, but that's something in the back of my mind as it relates to restitution. Thank you.
Any other questions? If not, I have a friend that's a business owner, and he lives in my county, and he was convicted of a nonviolent white collar crime. He lost his gun rights, and he lost his right to vote. He can't even protect himself at his business now. So I've always felt that if you've committed a crime and you've paid your dues and you've been paroled and you've been released and you've met all the court fines and restoration, you should be granted your rights back. Part of me wants part of this bill. The restoration part is somewhat of a concern. Also, I had a question you might be able to answer, or maybe you could get an answer, is over the years we have made certain offenses, whether they be a violent child molestation or a rape or something, we have made certain offenses carry harsher punishments than other felony crimes. Would this apply to all of them, or would it erase any of that, or do any change any of that? Because there's always somebody bringing a bill. We just voted on one the other day, last week, I believe, that gave more severe punishment than others for a particular crime. And I was wondering if any of that would be erased or none of that would apply.
No, it won't be. It won't be erased. Actually, right now, if you go to the Elections Division website, and you'll see there are certain stuff that's in statute right now that if you are convicted of any of those crimes, you're never eligible for them. And those are murder, rape, treason, felony bribery, misconduct involving a public official, interference with government operations, sexual offenses, violent sexual offenses that involve that are felonies where the victim was a minor, and voter fraud. So those are the ones that are in statute right now, that if you are convicted of any of those, you cannot vote. You will never be eligible to vote for those. And in addition to what's going on, and I showed you the flow chart, it also depends on when you were convicted. If you were convicted before 1973, there's a different statute for it. If you're convicted between 73 and 81, there's a different. If you were convicted after 2006. So the way in order to get your rights restored is so convoluted and so complex that the average person can't do it. That's why we have a 1% rate of people who actually successfully do this. And I think that we should be helping get people back, integrated into society, and helping feed democracy.
If I could, do you think you need to explain that about what was deleted? All right, I asked the legal a question, then he answered me back, and I'm not a lawyer, so it's always hard to me to understand a lawyer. But the codes you mentioned, what had been removed, that's in code, would that be removed, the codes that you mentioned earlier? I guess it's, 29204, persons never eligible for register and vote. Does yours also cover registration or just voting?
Registration and voting, I think it's both.
Okay.
You can't, you're not eligible ever under those.
But your bill is deleting that part of the law.
That's not my intention. I don't think that it's in. I don't think I think it's adding in there. I don't.
Well, we've got a session briefly just to legally explain that. It may have unintended consequences. Make sure you know what I'm questioning. Just when we're out of session.
Thank you, Mr. Chairman. Josh Hughes from Legal Services. So Section 9 of the bill deletes sections 49-29-203 through 40-29-205, and 40-29-204 is persons never eligible to register and vote. So if this bill were to pass, then those people that were convicted under those crimes would be able to register and vote.
Any questions? No, we're back in session. Any further questions?
Let me.
Representative Shaw. Right. And okay, Shaw.
Thank you, Mr. Chairman. Maybe my question's been answered, but I think I'm getting this because I got a piece of legislation that's probably the cousin or the uncle of this, whatever. Are your intentions, Mr. Leader, if I could,
Go ahead, I'm listening.
if I could ask you, were your intentions just to get the rights restored, or for them to be able to register and vote again too, or was it, can you just explain that to me? Because I'm not for sure I'm with you.
Yes, my intent is to make sure that people, after they have served their sentence and paid their debt back to society, whether it's been in incarceration, probation, parole, whatever it may be, that after they finish their complete sentences, that they're automatically they automatically can have their registration, be able to register to vote and vote.
Well, I asked you that question because, I mean, the way it was explained to me a couple of days ago, because I got a bill that is very similar to that, but because the codes are so different, codes are not a blanket code, if that makes good sense. I don't know if it does or not. For instance, if you committed a crime, another crime may not mirror that one in a way that the code is the same. And because of that, the codes are so different. It's hard to do a blanket, but it could be done maybe on individual basis based upon whatever your crime or your sentence was. I'm not for sure because I'm not a lawyer either, so I probably don't know what I'm talking about. But I think maybe that's where the bump in the road is that you're trying to do a blanket when it can only be done on an individual basis. Now, I know that takes longer. That's a long, drawn-out process, and I'm not saying I totally agree with the law on that, but I'm just kind of explaining to you what was explained to me, so I don't know if that's exactly what you are intended to do or not.
The goal is to make the process less cumbersome for someone to get there, to register to vote and be able to vote. Right now, as I showed you, it was 2 pages of a flow chart in order for someone to get their rights restored. Mm-hmm. And then it depends on the timing of when you were convicted. So I hope that answers your question.
It does, and I do think while I've got a chance to speak public and go on record, I do think that we as lawmakers need to find a way to make this simplify this process, because we got a lot of people caught up in catch-22s, and some of it is just simple stuff, and they don't know how to get out of it. And if there was some way we could fix this where it could be a simple process, and at the same time, mine and yours may not be the same, but it needs to be a simple process, because that's where a lot of people are right now in my district. They want an expungement, don't know how to get one. They wasn't taught, and no lawyers, anybody told them what they should do. They could have got diversion, didn't get it, just all kinds of things that people got paid for handling people's cases and didn't do well. So I just think that should be some kind of process, and I'm not for sure if I know what it is, but I sure would like to be a part of trying to figure that out, because we do have a problem. We have a big problem with that. And I really appreciate these people coming to testify and tell their story, because it really is a problem. Thank you.
Vice Chairman Wright.
Thank you, Mr. Chairman. I agree with my colleague, the Honorable Shaw, in that we do need a process. But there's 2 or 3 places that I got lost in the presentation. One presenter saying if we pass this, it would allow the person to regain rights for which they have no path right now. I agree I think there should be a pathway for restoration of voting rights. But then it's brought to us by legal that there are certain, and we just passed one maybe in the last week, that would withhold voting rights for a lifetime. This process of being restored needs to be simplified. This being lost in the system, that's unacceptable. So what I think is I see too many bullet points in this bill for it to be then passed, I'm speaking only for myself, for it to be passed with some people thinking this is an end-all, cure-all, when it can't be. We need maybe we need a study, maybe we need several individual bills so we can thrash out just one point at a time. But as we have before us, I think, a big bill, there are too many questions in it for me. And I appreciate your presentation. Thank you.
If not, I'll go on the next question, or, okay,
go
Representative Love.
Thank you, Mr. Chairman. And I believe one of the presenters made this statement, and the sponsor can answer this question as well. This legislation does not absolve the person from their obligations financially, correct?
No.
Is it your belief that if a person is given the right to vote, and I heard one of the presenters speak to this point, that even their spirits lifted and they may find themselves more willing to engage the process, and there's no connection between people being withheld the right to vote and restitution, correct?
Correct. Like in Florida, there's been studies that shown that people they had an automatic restoration bill that passed, I think, a couple of years ago. And what it has shown that people who have engaged in the process, the recidivism rate has dropped and it decreased dramatically. And so I think that there is a correlation between voting and being a productive citizen and having the ability to take part in society.
Thank you, Mr. Chairman. Thank you, Ms. Sponsor.
Chairman Crawford.
Thank you, Mr. Chairman. And sponsor, there's a lot of questions about this bill, and there's no question that we need to make some adjustments and fix a few things in the law. But there, with the untimely filed amendment and trying to chase it down through the regular bill, what it changes and what it don't, I mean, you haven't given us enough time to figure that out. So I would ask you if you would be willing to roll it a week so we can dig into it. But that's your decision. You can or you can't. Doesn't matter. I'm trying to follow it and can't do it.
I appreciate your candidness. I don't mind rolling it a week because I do have I didn't see that code that you got from legal, and that was not my intention. That would give me time to fix it, and also that would give me some time to hopefully work with you and address any issues that you may have, and that we can try to actually do something that really works, at least start the framework of something that really works and that helps Tennesseans get back and being a part of being a productive society.
You had one more, Chairman Crawford, and then we got one more question.
When you said that, that just jogged my memory. Why don't would you be willing to send it to summer study and let us study it over the summer?
I'd be willing to roll it 1 week to see where we can come.
Thank you.
Chairman Williams.
Thank you. I was going to make a similar suggestion, mainly because you seemed surprised when legal gave you the information about all the ability to get restored rights. I don't want to defraud you, though. When you leave and come back and try to fix that issue, I'm still going to have an issue with restitution. When people commit crimes, they're victims. Victims are due every portion of the crime that was done, regardless of age. And so restitution is a really important part. If restitution is not a component of restoring your voting rights, then I'm not going to be able to support it then. Just wanted to give you a heads up as you look at the new draft language.
Sponsor.
Like I said, there's 35 states that have passed this legislation, and several of them they don't even consider restitution in there. And I think it's proven that in those states, it's helping people get back to be productive in society. What I would like to do is still roll it a week. Let me see if I can answer some of those questions. Let me do what we can. And if we can't, and if there is an earnest ability and an earnest statement to actually study this, then at that time, I will consider it. But we have to be able to study this because this is too important to too many people to send it to summer study and feel the cold wind blowing and then let it die. This is something that can be meaningful, that can help everyone, I guarantee you, someone in all of our districts, and sometimes in our families. So if we can roll it a week, Mr. Chairman, would you be amenable to that?
The sponsors asked to roll it. Representative Shaw's asked to speak. You prepared to let it roll, or you want to say something? Okay. Will you mind? Okay.
No, sir.
Representative Shaw.
Thank you, Mr. Chairman. I feel a cold wind in terms of getting the bill passed like it is, and I've learned something in my life. I don't lose my dream because I don't get success when I first start. And I'm just kind of passing this advice on to you. I would love to get with you because I got legislation, and I would love for us to get with some folks over the summer, and we try to come up with something that would be something to help everybody, because I know now, Mr. Leader, you're not going to get it passed this year. I hate to say that, but you're not. You might have 2 votes over here, but you don't have enough votes to get it passed. I'm begging you, let's get together and do something this year to some. You are right. That's a problem. That's a problem. In my district, your district, and every district up here has got the same problem. But we know the minds are set of some people. So let's get some attorneys, let's get some people together, and let's come up with some legislation that'll work to help these poor people who are in this predicament and shouldn't be. And I think if we do it right, it'll help a lot more people than trying to get a quick fix and don't get nothing done. I'm begging you. I'm publicly begging you to let's do that, because I like what you're doing and I want to help fix it because I got the same problem.
Representative Shaw, you never have to beg me for anything, but I do take your advice and your leadership under counsel, and I do appreciate you taking the time to speak with me and really be earnest about it. But at the end of the day, I really don't mind. This is a big bite to chew. It is a big bite to chew, and I totally understand that. But are we willing? Do we have the appetite for what we're getting ready to put in our mouth? I know you do. But unfortunately, you're not in control of the summer study. And that's not to be taken it light. If we can commit to literally doing this, I will have no problem with doing that.
We have one more member of the committee that's on the list to make a comment, Chairman Hosclaw. And then we can...
Thank you, Chairman Committee. And I do agree. There's so many issues here. I mean, the concept's great, and I think with my counterparts that something does need to be done, and we want to fix that and correct that, but there's way too many issues. I think we need to look at that flow chart. We need to simplify it, make it easy so they can go in. 1 or 2 things are either register to vote or not. Make it very simple. So, I'm of the cold wind feeling too. I think we need to really summer study this thing. So with that, that's my recommendation, Mr. Chairman. Thank you.
Can I respond before you make the motion? I mean, or after you make the motion, can I respond? Whatever, however, whatever the parliamentary. Can I do it before you make the motion?
Was that a motion? Do I hear a second? Sponsor, you want to?
Just wanted to make a comment. Again, I'm okay with sending it to summer study if I have a commitment from each of you that you send me your questions, you take the time to look at this bill, really digest it, look at what it does, and we have a commitment that we, in summer study, this will actually be studied, and we can come with some real solutions and file some legislation that actually gets this done.
Well, you have my word that if this is sent to summer study with the vote we're about to take, I will personally go to the speaker and ask for a real summer study to be conducted, because this is a serious but a very complicated thing. Like I said, there's several issues where there's some felonies that are more severe than others. There might get resistance on addressing those. We need to check about the code, see if it's damaging anything else, and how to implement this. Who's going to review it? It could be partisan parole board that takes it up. I don't know, but we do have a motion and a second on the floor to send this to summer study. All those in favor say aye. Aye. Opposed, nay. It is approved to go to summer study.
Thank you, Mr. Chairman and committee.
Also, I want to take care of something else. We have several bills, before we go on to the rest of the calendar, we have several bills that have been rolled or taken off notice. I want to take care of those. Item number 6, HB 1914, has been rolled 1 week. Item number 8 by Dixie, 2489, rolled 1 week. Item number 9, 2121 by Warner, has been rolled 1 week. Item number 10 by Parkinson has been taken off notice. That is 2827. And I believe that is all the calendar that was, as of right now, that was adjusted. We can proceed on with the calendar. Next up is number 11 by Representative Chairman Lynn. Is Lynn in here? Oh, I'm sorry. 11 to the hill. Okay. Then number 12 by Mr. Representative Hardaway. 2813 from the desk. Excuse me, the sponsors requested that HB 2813 be rolled 1 week. All right, that puts us on item number 13, HB 1004 by Representative Love. The sponsors requested that HB 1004 roll 1 week. Item number 14, HB 2101 by Mayor of Oval City, Representative Shaw.
Thank you, sir. You know, that sounds good. That mayor part sounds real good. I like that. I'm on. Today, thank you so much, Chairman. This bill is a bill that was brought to me by Senator Gilmore, and of course, it's been a big concern of hers for quite a while. And what the bill does, the bill really introduce or create a polling place pilot program for Davidson County only, for the inmates in Davidson County, for those who are eligible to vote. And today, Mr. Chairman, we have a young lady here to testify on this. If we could go out of session for about 3 or 4 minutes, Ms. Jacola Lane, who will testify about this bill. And then what I'd like to do is to roll it for 1 week, if I could.
All right, we'll go out of session to hear. Please make sure the red light is, or the button there on the left, and then introduce yourself. We're going out of session.
Okay. The next one. Okay.
Good afternoon.
Yeah.
Good afternoon, House Chair Rudd and committee members. My name is Jacola Lane, and I am testifying in support of House Bill 2101. I am a Davidson County resident, and I'm a voting rights advocate at Campaign Legal Center. You heard from my colleague earlier on the voter restoration bill. Campaign Legal Center is an advocacy primarily focused on ballot access across jails and restoration That is my focus. It's a nonpartisan, nonprofit organization based in D.C. working to protect and strengthen the U.S. democratic process across all levels of government through litigation, policy analysis, and public education. I work specifically with voting rights lawyers, policymakers, and state and local advocates every day, supporting their efforts to combat jail-based disenfranchisement across the country. Tennessee is not alone working to ensure that eligible incarcerated voters can exercise their right to vote, including improving their election infrastructure and accessibility to incarcerated voters. Just last year, Washington, D.C. implemented its universal enfranchisement measure, and Maryland became the second state in the country to have created election infrastructure specifically for incarcerated voters. Organizations across the country are working to create jail voting infrastructure, including Arizona, California, Colorado, Florida, Maryland, Michigan, Ohio, Pennsylvania, Texas, Wisconsin, and Virginia. Jails in Los Angeles County, Washington, D.C., Cook County, Illinois are all currently facilitating in-person jail voting. We are pleased that Tennessee is joining the growing number of states working to ensure all eligible voters can access the ballot, but voting from jail remains incredibly difficult for over 17,000 eligible incarcerated voters in the state of Tennessee. And across the nation, there are 750,000 people who are jailed who are eligible to vote. While many jailed voters retain their constitutional right to vote, few actually are able to cast ballots. This is not because they lack an interest in voting, it is because they often can't vote. It is because of jail-based disenfranchisement. Jail-based disenfranchisement is not the result of one bad law. Instead, it is caused by a complicated, convoluted net of practical barriers that deprive eligible incarcerated voters of their constitutional right to vote. And although the Supreme Court has affirmed that eligible voters cannot be disenfranchised simply because they are incarcerated, barriers to ballot access from jail remain prolific. I ask you to please consider passing this bill. Davidson County Sheriff Hall has met with us, is in support of this, and we would love to show that the state of Tennessee can allow people who have their constitutional right to vote, even though they are incarcerated, to actually be able to do it. Thank you.
Are there any questions, Ms. Lane? Representative Shaw.
Thank you, Ms. Lane. Thank you for your testimony. Now, what I understand, this would be a pilot program, and I understand this would be those who would be eligible to vote even if they were guilty of the crime. Certain crimes, they may still be eligible to vote, because I know that is the case. And you're only asking for those that just would be eligible to vote.
That is correct.
And your sheriff and people in Davidson County would set up a pilot to do that at a certain time, because they may be incarcerated on voting day or...
That is correct. And we have talked to them about logistics, as well as Jeff Roberts from the Davidson County Election Commission. We have facilitated a conversation with both of them. Sheriff Hall and the Sheriff's Department is totally on board, and has also submitted a letter stating that, in fact, they support this pilot program as well.
All right. Thank you.
You're welcome.
Chairman Williams.
Thank you. Quick question. Is there anything in state statute now that prevents Davidson County's Election Commission from holding a precinct in a prison?
There is not. And so I just want to make sure we're talking about the jail specifically. So the jails and prisons are separate, but there are people also in prison, as you all know, that are eligible as well, because we do have that time period where many people did not lose their right to vote, although they were convicted of a felony. But specifically in the jail, there are people who are eligible who have not been convicted yet, or who may not have even have a felony conviction, or may not even have to get their rights restored because they are only, convicted of misdemeanors while they're waiting pretrial, et cetera.
Chairman Williams.
Thank you. The reason for that question is there's no need for a state law modification for them to go ahead and do it now. It sounds to me like the local Davidson Election Commission just doesn't have the willingness to do it. They may give you a letter, but if they can set up a precinct in a jail or prison, they can do that. Nothing's preventing them from do that, because they've got to qualify that they're qualified voters. I guess the question is is also, do you represent anybody that's currently in a lawsuit with the state of Tennessee over elections, or are
I'm
you?
not an attorney. I just work at Campaign Legal Center.
Okay, but is your entity in a current lawsuit with the state of Tennessee over elections?
We have a lawsuit over out-of-state convictions for rights restoration, but it's not for the jail voting, which I'm speaking to.
Okay, so you are your entity is in a current lawsuit with the state of Tennessee for restitution of voter rights for people who are not citizens of the state.
No, not exactly. We have an ongoing litigation about people who are trying to get their rights restored in Tennessee, but may have been convicted in another state, but they reside here in Tennessee. But I'm just speaking on the matter of the jail voting pilot. And I'm also a Davidson County resident, and I have worked with other organizations and Senator Gilmore and others locally to try to facilitate jail voting before I even worked at Campaign Legal Center as well, which has been an ongoing issue since about 2016, once we started this effort to try to help facilitate jail voting in Davidson County.
Well, I appreciate your efforts. I think they're valiant. I just think that you have a mechanism by which to do it now, and the former Metro Councilman, current state senator, should be able to petition their local election commission to get precinct in a jail. So I hate that you had to come all the way here today and testify just to do something you could already do anyways, but appreciate your testimony today.
Thank you.
Representative Wedlove, and he's next on the list.
Okay.
Thank you, Ms. Lane, for being here, and I thank you for clearing up. That's one of the questions I was going to ask is about the fact that there may actually be people in the jails who are waiting for trial, and for whatever reason, maybe they have no money for the bail or something else is going on, who aren't able to vote as they're waiting to maybe have their innocence proved, but they can't vote because they're in the jail and there's no voting precinct there. Is that correct?
That's correct. And right now, there is a process that is very complicated. They do an absentee ballot, what they call the inmate absentee ballot. And we have talked about the issues that come up with that. And yes, these people, a lot of people have not been convicted, and they're in this pre-trial, what they would consider stage. And there are all types of areas that we have seen the last 5 years that is not allowing people who have the constitutional right to vote, that are incarcerated in our jail, not to vote.
Thank you.
You're welcome.
Representative Shaw, is this to the okay, because we need to.
Briefly, I know we need to go on, but
Well, we need to go back into session.
back in session, but this is to her. But I just wanted to ask you if based upon what my colleague said at the other end of the line, if you can already do it, what would a state law do that you can't do now, I guess is my question to you since you're here.
Absolutely. Great question. So we wanted to use this as a pilot in Davidson County to eventually be able to have everyone across the state who are eligible voters, because the same thing that happens in Davidson County where someone has their right to vote is being denied because the facilitation of the inmate absentee ballot applications are not being accurately handled in all 95 counties across the state of Tennessee. And our hope is to show that this can be done, it can be done well, that there are sheriff's associations and election commissioners who would be willing to make sure that everyone who has the right to vote is able to exercise that right to vote.
Is it not true currently? I know in most counties, and Davidson as well, I believe, doesn't the county election commission go to the jails now and offer prisoners who have not been convicted of a crime the right to vote?
So again, there is a difference between a jail and a prison. However, they are supposed to be, yes. But again, there are a lot of barriers that still exist, although there is this absentee ballot process that exists in the rules. And we have seen it over and over where people have requested it. There are complications all over the state of Tennessee with people being able to actually exercise their right to vote. And we have research that we have provided about that. We have, again, over 17,000 eligible These aren't folks who are ineligible. They are eligible and have their right to vote who have not been able to do that because of all the complications. And sometimes it's just simple things that they just aren't able to execute on. I have physically gone to the Election Commission to pick up forms myself because there have been people in the jail who have requested to get their ballot and have not received them. And so that same matter is happening all over the state of Tennessee. I'm not saying it's intentional, but I think that is so complicated with the current process that exists that it's not being carried out well, and everyone is not in alignment across all 95 states about what that process is. There's a huge gap in education about what it should be happening from the sheriff's level in connection with the election commissions.
Chairman Williams.
Thank you. Once again, I feel like I'm being redundant, but the facts are the Election Commission can currently do that. If the Election Commission is not doing it, and the citizens of that community are disappointed in who their election commissioners are because they're unwilling to do that, the mechanism for that is this is an election year. So the House Senate members from Davidson County get together and they appoint new people to make sure they understand to represent the rights of those people that are incarcerated that want to vote. If they don't do that, it's not the it's not our role to do that. There's already a system in place for it. One of my colleagues today already voted against this bill because there's already a policy in place. So we have to follow the policy that's in place. There is something that works, but just because somebody doesn't do what we want them to do doesn't mean we come to the state and ask them to pass a bill to force them to do it. And so I appreciate your testimony today. I think you're doing a great work. You're obviously very passionate about it, but I do think that's the means by which to fix it. Thank you.
If there's no other questions, Ms. Lane, we'll go back into session. Thank you. We are now back in session, and I believe you, Representative Shaw, wanted to. So you wanted to row HB 2101 1 week? All right. No objections? We row 1 week. We're now back at the top of the calendar again. We're back on item number 3, HB 2074 by Mr. Griffey.
Good afternoon, Mr. Chairman, members of the committee.
And hear a motion and a second on the bill. Hear a motion and a second. Second. Hear a motion and second on the bill. Let's see, I believe you have, an amendment?
Yes, Mr. Chairman, there's an untimely amendment.
This is untimely.
And I do have someone here that wanted to testify, Janice Cronasi from the Hardin County Election Commission Administrator, to explain the system that they already have in place, and it's what many of you may have seen upstairs on the 8th floor on Monday.
Do I hear a motion to hear an untimely amendment? Do I hear a second? A motion or a second? Yes.
I don't have a copy of the untimely filed amendment. The member hasn't communicated with my office, and particularly, we just rolled 27 of 28 bills to next week. And so I guess my point is that I don't understand what the rush would be to do that. I have concerns with the member's bill based upon communication from my election commission and its contrary nature or standing to that of Representative Bricken. So I guess I don't know what the reason for the parliamentary inquiry is, to find out where we are as it relates to 2704. Are we on the first row, second row, third row, third hearing?
Where we are is we're on a motion. We had a motion. We're lacking a second. What, to hear the bill, or no, to actually have the amendment? We've already voted to hear an untimely filed amendment. Now we're voting on putting the amendment on the bill. And
we're Chairman, not to be a contrarian, we're on the bill. We have no motion is second on an untimely filed amendment.
Correct. Excuse me. We have a motion with no second to hear an untimely filed amendment.
Okay. Well, as I said before, with all due respect to the member, no copy of the amendment, have no idea what it says. In Washington, they may pass stuff without reading it, but I'm not going to. That's why I'm a little bit concerned about the untimely filed nature of the amendment and its contrary nature, which I'm told to my local election commission.
Chairman, Representative Griffin.
Thank you very much, and I apologize that it was late. I was trying to correct a problem. Because Rush Bricken's bill essentially does what my bill did as originally drafted in 2704, I had spoken with Chairman Crawford about an alternative that I think this committee may want to consider, and that's the purpose of the untimely amendment. I have a copy here. It's fairly self-explanatory, but if we maybe can push to next week, I did have Ms. Crossney here from Hardin County to.
I have this suggestion, and researchers remind me, we do have a motion second on the bill, not on hearing the untimely filed amendment. They want a chance to read it. So we can, if you so choose, have testimony today, because we still have 10 minutes, 10 or 12 minutes, and then you request to roll the bill immediately afterwards.
Please.
All right, well, if anyone wanting to excuse me, we have 3 people wanting to testify. If you'll come to the front table and be sure and activate the red button when you speak. Tell us your name and if you represent any organization, and please keep it to 3 minutes apiece.
Okay. My name is Jeanette Cronice, and I am the Administrator of Elections in Hardin County. In 2015, our Election Commission decided to look at all the available voting machines that were approved by the State Election Commission. It became clear to us that we needed a paper verifiable trail, and we purchased ballot marking devices for every polling precinct, and we purchased a tabulator. So we wanted the voters to have accessibility for every voter. Every ballot marking device is ADA compliant. It can change color contrast. You can
Make calls in a minute. I forgot to be a heavy hand. We're going out of session. Now proceed.
So the bottom line is the ballot marking devices do not tabulate votes, and they are ADA accessible. That's the 2 takeaways that you need to know about those. The paper verifiable trail, we have a ballot card that we insert into the ballot marking device. The voter has the ability to review their candidate selections before they even print their ballot. Once they print their ballot, they can review it again, and then they can put it in a tabulator, which ultimately counts their vote. If they make a mistake on that paper ballot and they say, oh, I didn't mean to do that, as long as it's not put in the tabulator, it doesn't count yet, so we can give them another try at the ballot marking device. The other option is they can vote strictly on a paper ballot. So the beauty of the paper verifiable trail is that we hold those ballots for a specific amount of months. In the event that the election is over, if there's a question, we have that paper to verify everybody's selections. We also do audits for specific elections where we take the flash drive out of the tabulator, put it into another tabulator, rerun all those ballots again, and verify that everything matches. So the people really like looking at a paper ballot and knowing that they actually made those selections, that their selections are being counted. I guess I could go on more and more about that, but the importance here is having that paper ballot backup. Integrity, absolutely. I'm open for any questions if anybody has any. I try to keep my remarks short and sweet.
Any questions? Seeing none. Next up, I believe, is what, Kathy Harms? Is she here? Is she wanting to speak?
She may not be here.
Okay. Next on the list was Deborah Maggart.
Thank you, Mr. Chairman. And can I have a parliamentary inquiry? I want to make sure I understand where we are. We're on his bill.
We're on his bill. We're hearing testimony, but he has said he has indicated after testimony he's going to roll his bill, I believe, a week.
Okay. So I'm Deborah Maggard. I work for a firm called Civic Point, and I'm here representing Microvote. And I want to thank you all who came by Monday to our vendor fair and saw our VVPAT printer. Many of you all know that Microvote has been in business in Tennessee for about 35 years. Microvote is a small family-owned business that has been in business for about 40 years. We do have a paper solution. We have our machine in about 45 counties here in Tennessee, and we have a voter verifiable paper audit trail printer. So our folks are very happy with our customer service, and we are excited about our new printer. Our voters can see on the screen their selections, and then they can look at their paper ballot, and before they cast their vote, they can verify on the printer how they were placing their vote. So I just wanted to let you all know that as the sponsor's bill is written right now, it would not include Microvote in his original bill. So I wanted to let you all know that we were opposed to his original bill. I did work with the sponsor on some amendment language to include Microvote, and I know we're not on the amendment, but the amendment as written today, we would also be opposed to that. So thank you, Mr. Chairman.
Are there any questions of Ms. Maggard? Seeing, no questions to.
Well, I could ask, maybe I should have asked the First Lady rather than Deborah, because what I want to know, is this one county we're talking about, is this a statewide application?
This would apply statewide.
It would apply statewide, but I guess my question is there a problem in any other counties with a paper ballot other than this county, is what I'm asking, in Tennessee?
I don't know. We'd have to go back in a session. I have to sponsor. I know that the bill and the amendment would affect 85 counties, I believe. Any other questions? If not, thank you, Ms. Maggard. We'll go back into session.
Thank you, Mr. Chairman.
Yeah, Chairman Crawford.
Thank you. I have a question on the bill for the sponsor. You said that one of the other representatives had a bill that basically does the same thing that's already passed. Is that correct?
It's my understanding, and I believe I was in here when Representative Bricken presented his bill. He's got a bill that has a paper verifiable voter paper audit trail. And essentially, that's what this bill is trying to accomplish.
Okay.
But because his covered that, that's why I had an untimely amendment, but I would like to share with the committee, because I think it does something completely different down the road.
Okay.
Chairman Crawford.
Can you, Mr. Sponsor, then tell us, my understanding when I read the amendment was that it allowed them to have 8 years to purchase the machine to do the hand votes? Is that all it does?
Thank you. Thank you, Mr. Chairman.
Representative
It's my
Griffey.
understanding currently in Tennessee, there's 67 counties that still use DRE machines, the direct recording electronic voting machines. There is no way to go back if there's a question really to figure out who voted for what. I think we're all trying to get here in Tennessee, based upon the November 22 election, concerns about being able to have transparencies in elections. And if there is a dispute or a question, we can go back and there's something to count, and there's a verifiable paper audit trail to do that. And I think if all of you had a chance to go up to the 8th floor Monday and look at the equipment, it's very impressive. My only criticism of some of the equipment up there on the 8th floor, and even the ballot marking devices, most of them, when they print a ballot that's later scanned into a tabulator for counting, they're printing a QR code or a bar scan code onto the computer, a ballot, paper ballot. And the tabulator is actually reading that QR code or that scan code that's supposedly compiling the various votes, the various candidates, school board, county mayor, those. So The problem is, and we saw this in Wisconsin from the Supreme Court justice up there that was investigating the problems up there. There was somebody, it was a vendor that was actually hooked in wirelessly, running everything in the county where, Green Bay, Wisconsin, that county. And it was a vendor running the elections from a hotel room in there. The problem is we don't have transparency when we rely on computers. And so what my amendment would do, I think everyone may agree that hand-marked paper ballots are the gold standards, except for ADA compliant folks that need assistance with that. That's not a huge threat. But if we have hand-marked paper ballots that can always go back and look to and see how they're marked on that, and that's what counts, rather than a QR code or something that a machine tabulates and gives you a figure, because there could be nefarious act. I'm not saying there are, but there could be nefarious actors. So if we want to be absolutely certain down the road at any other election, if you got a hand-marked paper ballot, that would do it. And it's also my understanding that most election administrators, they'll do whatever we direct them to do, how they wanted to do it. Their concern is that they have time to cycle in new equipment so it doesn't cost the county and the taxpayers a bunch of new money for new equipment. So what the amendment was going to do is say, at some point in 8 years from now till 8 years down the road, every county needs to go to a hand-marked paper ballot, except for ADA compliant people, and they can use the ballot marking devices because they're not as a big a possibility of susceptible to manipulation if there was bad actors. But this would give them, and they could do it sooner if they wanted to, but it would do that. So that's where we are with the bill. And I apologize I couldn't get to all of you all. It's just been a crazy week. So,
Chairman Crawford.
So you said all that. Tell me what the difference is on the amendment. Tell me what the amendment does.
The amendment says that each county commission shall require voters, other than voters who are qualified as disabled under the American with Disability Act, to use hand-marked paper ballots that are tabulated by hand or machine not later than the earlier of when the county election commission purchases new equipment, or July 1st, 2030. That's 8 years out from now.
So that's all your amendment does, is put 8 years time period for them to buy the machine.
Yes, the local commission can immediately use them if they want to. The Secretary of State shall assist if necessary in doing that. And for legally purposes, how a vote is counted, the amendment says that the vote is what the voter marks on the hand piece of paper, not what the computer spits out to them. So if you go back and count them later, we're counting that stack of ballots and seeing how they're marked on the ballot, not what the machine spit out and told us is calculated.
Mr. Sponsor, someone point out to me, we've been through so much today, and in this unusual circumstance, your bill.
And
we went out of session to hear the testimony. We've now come back into the session. We're discussing an amendment that that couldn't get a second. So, and then he was going to request a roll of the week. So that's kind of where we're at now. So I guess if we're going to continue to discuss the amendment, we need to adapt it, or we need to let the sponsor.
You guys want to get out of here and let's just roll till next week?
We got to get out of here anyway before minutes.
I would appreciate that, and my appreciation to the committee for your indulgence of being.
Fear no objections. Chairman Williams.
Thank you. I think you were right in communicating about the ADA component of it is the only difference, but you also went on to say discussion about the actual machines themselves. I told someone in the previous bill, my concern is currently Representative Bricken's bill allows for the people in my community to vote with a verifiable paper trail, of which the funding of those machines or new machines would be paid for by the Secretary of State's office through monies he already got. I don't really understand the reason why you need a bill if we've got all that lined up with his bill and you agree that it does exactly the same thing and you don't have the ADA problem. So you got a lot of work ahead of you, and I'm happy to roll it for you to give you the time to sort it all out. But if the amendment comes back and it eliminates Putnam County and 32 other counties from their ability to do a verified paper trail with what they currently have on hand, then I'm probably not going to be supportive of the bill. So we need to get together and sort it out.
Thank you.
All right. No
Could I
further
roll the week
questions.
Continue. Could I roll it a week then?
All right, the sponsors asked to roll HB 2074 1 week. All due to time restraints, the remaining bills will be automatically rolled 1 week or heard next week. Also, if I would suggest before we adjourn, I would suggest the sponsor get with Representative Bricken. We're getting to the point now where there's so many bills that are trying to do the same thing that once we pass some good bills, others are going to have to start dying, or they're going to start overriding good other bills. So I encourage not only you, but all the sponsors to get together that have similar bills and start talking to one another. All right, thank you. With no objections, we're hereby, I think Chairman Williams wants to stay, doesn't you? Want to? Yeah, I do. Okay. With no objections, we're adjourned until next week. Thank you.